rise, if vous levez. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du Tribunal Pénal International pour l'ex-Yougoslavie est ouverte. Please be seated.
The Chamber is sitting today to deliver judgment in the trial of the accused Vlastimir Đorđević. For the purposes of this hearing, the Chamber will summarise briefly its findings, emphasising that this is a summary only and that the only authoritative account of the Chamber's findings and its reasons for those findings is to be found in the written judgment, copies of which will be made available to the parties at the conclusion of this sitting. The accused Vlastimir Đorđević is charged for his involvement in crimes committed by Serbian forces, especially army, the VJ, and police, the MUP or MUP, against Kosovo Albanians in Kosovo in 1999, principally between March and June 1999. In particular, it is alleged in the indictment that Serbian forces systematically shelled towns and villages, burned homes and farms, murdered over 800 Kosovo Albanian men, women and children, damaged and destroyed Kosovo Albanian cultural and religious institutions, and sexually assaulted Kosovo Albanian women. It is further alleged that this conduct resulted in the deportation from Kosovo of approximately 800,000 Kosovo Albanians. These allegations support the 5 charges in the indictment of crimes against humanity and war crimes. These charges are for the crimes of deportation, forcible transfer, 2 counts of murder, one being charged as a war crime and the other as a crime against humanity, and persecutions. At the time of the events alleged in the indictment, the accused held the office of Assistant Minister of Internal Affairs of Serbia. I will refer to the Ministry of Internal Affairs as the MUP or MUP, or the Ministry. Within the Ministry, he was the Chief of the Public Security Department, the RJB, which may be likened to the position in many countries of Chief of the Police Force. He held the rank of Colonel General, which was the highest rank within the MUP. It is alleged that, as Chief of the Public Security Department, he commanded and exercised effective control over, in particular, the Special Police Units, PJP, and of the Special Anti-Terrorist Unit, SAJ, and of the police force, regular and reserve police, as well as volunteer groups and other units operating in concert with the police. The accused is charged under Article 7.1 of the Statute of the Tribunal with planning, instigating, ordering, and otherwise aiding and abetting the alleged crimes. The accused is also charged under Article 7.1 with committing these 5 crimes by participating in a joint criminal enterprise, a JCE, the purpose of which is alleged to have been to change the ethnic balance in Kosovo so that Kosovo Albanians were no longer in the majority in order to ensure continued Serbian control in Kosovo. It is also alleged in the indictment that the accused is liable under Article 7.3 of the statute for failing to prevent the offences committed by police under his command and for failing to ensure the offenders were punished for the offences they committed. The accused was initially indicted in 2003, together with Army General Nebojša Pavković, Army General Vladimir Lazarević, and Police General Sreten Lukic. This case was subsequently joined with the similar case against Milan Miljutinović, the President of Serbia, Nikola Sajnović, the Deputy Prime Minister of the Federal Republic of Yugoslavia, FRY, and Army General Dragoljub Ojdanić. The trial of these 6 other persons commenced in 2006, but the case against the accused was delayed because he was still at large. Eventually, he was arrested on the 17th of June 2007 in Montenegro and was transferred to The Hague. He pleaded not guilty to all counts in the indictment and has had to be tried separately from the others. His trial commenced on the 27th of January 2009. It has been a lengthy and complex case. The Chamber has heard over 140 witnesses and has admitted in evidence over 2,500 exhibits, including many orders and reports of the MUP and the VJ, and records of meetings of the Serbian political, police, and military leaderships. For the tribunal to have power to deal with the crimes charged against the accused, it must be proved by the prosecution that an armed conflict existed in Kosovo at the time, and for crimes against humanity, that the crimes charged were committed in the context of a widespread or systematic attack against a civilian population. For reasons set out in the written judgment, the Chamber is satisfied that by the end of May 1998, an armed conflict existed in Kosovo between Serbian forces, in particular forces of the VJ and the MUP, and the force usually referred to as the Kosovo Liberation Army, the KLA. This armed conflict continued until at least June 1999. In addition, on 24 March 1999, NATO commenced military operations in the Federal Republic of Yugoslavia, so that the Chamber is also satisfied that from 24 March 1999 until the end of hostilities in June 1999, an international armed conflict existed in Kosovo between Serbian forces and the forces of NATO. Having considered in particular the scale of destruction and damage to Kosovo Albanian civilian property, the loss of civilian lives, and the displacement of Kosovo Albanians in Kosovo in 1998 and 1999, the Chamber is satisfied that the offences charged took place in the context of an armed conflict in which there was a widespread and systematic attack against the civilian Kosovo Albanian population. Hence, the preliminary requirements of Article 3, war crimes, and Article 5, crimes against humanity of the statute, have thus been proved. As discussed in detail in Chapter 6 of the judgment, beginning relevantly on 24 March 1999, a consistent pattern of events occurred in many towns, villages, and other locations throughout Kosovo. By way of typical example, in the early morning hours, VJ and MUP forces would approach a village, town, or other location. The VJ, using tanks, armoured vehicles, and other heavy weapons, would shell the residential area, causing the Kosovo Albanian population to flee from their homes. Serbian forces, in most cases police, would then enter the area on foot, typically setting houses on fire and looting valuables. In some cases following these events, VJ and MUP forces then ordered the whole population to leave, sometimes physically harming individuals and looting people's valuables. In many of these locations, after the initial shelling by the VJ, Serbian forces, in several cases specifically identified as forces of the MUP, then approached the residents and, typically, separated the men from the women and young children, ordered the women and children to leave to go to Albania, and then killed all the men, usually having first divided them into smaller groups and taken each group to an isolated location. Many residents and displaced persons who witnessed heavy property destruction and damage, as well as killings by Serbian forces, by their own decision left their town, village or city in large numbers out of fear for their lives and welfare. Serbian forces coordinated the process by directing the mass movements of Kosovo Albanian residents away from their towns and villages, often organising road or rail transport, and in most cases ensuring that the people reached and crossed the border, mostly into Albania or the former Yugoslav Republic of Macedonia. Massive columns or convoys of Kosovo Albanian people moving to Albania or to Macedonia formed throughout Kosovo and eventually crossed the border out of Kosovo. Some Kosovo Albanians even crossed the border into Montenegro. It was the defence contention that there were many reasons why people left Kosovo at the time, including the state of war between the FRY and NATO, the NATO bombing, fighting between the KLA and Serbian forces, sanctions and wartime conditions, evacuations and deliberate population movements directed by the KLA. It was also contended that the non-Albanian population of Kosovo was also leaving Kosovo at a comparable rate. In determining whether the offences of deportation or forcible transfer have been established, the Chamber has relied on the evidence establishing the circumstances in which people left towns, villages and cities in the 13 municipalities listed in the indictment. From this evidence, the Chamber is satisfied that the offences of deportation or forcible transfer have been established with respect to some 60 specific locations which are listed in the written judgment. With respect to each of these locations for which the offences of forcible transfer or deportation have been established, the evidence does not reveal that people were leaving because of NATO bombing or because of fighting between the Serbian forces and the KLA or because of hardship caused by sanctions or wartime conditions, as the defence has contended. On the contrary, the evidence discloses, as discussed in detail in the judgment, that the Kosovo Albanian people left Kosovo because they were specifically ordered to do so by Serbian forces, or because the conduct of Serbian forces caused them to leave, in particular by shelling, shooting, killing, and by burning houses and other buildings in their villages, towns and cities. While factors such as NATO bombing and fighting between the Serbian forces and the KLA may have caused some concern in the minds of some Kosovo Albanians, the factor which was dominant and compelling in causing Kosovo Albanians to leave their homes, and in many cases causing them to leave Kosovo, was the deliberate campaign of violence and terror conducted against Kosovo Albanian civilians by Serbian forces. In this respect, it is significant that in most cases, identification documents and vehicle licence plates were seized from the Kosovo Albanians before they crossed the border out of Kosovo. This seizure was by Serbian police and VJ.